and Penny. Now, ladies and gentlemen, the moment that we've all been waiting for, I'd like to introduce once again our honored guest speaker for this session, Ms. Farah Diba Muhammad Sofian Faradiba, who is a partner at Messrs. Wong Yin and Tunku Alina. As I mentioned briefly just now, Ms. Farah's talk will cover wealth planning concerning inheritance, succession, and other legal matters. So, if you want to ensure that your wealth can be preserved for generations after you, ladies and gentlemen, this talk is for you. With that, I would like to hand it over to Ms. Farah. Over to you, Ms. Farah, if you're ready.
Thank you. Thank you, Raj. Yes, I didn't realize I'm the first speaker for the event. So perhaps and assalamualaikum to everyone and good morning to everybody as well. Thank you to Amazing Seniors for inviting me to be part of your Amazing Seniors event. You said that it's life begins at 50. I'm already 53, by the way. So I'm one of the senior members here as well. I think my topic today is about wealth planning in the context of inheritance and distribution. Why is it that I chose this topic? It's because I think at this age, we've done a lot of wealth accumulation, wealth preservation. So I would like to share with our registrants as to the difference between wealth planning and wealth distribution. Do you know what is the difference between wealth planning and wealth distribution? Actually, it's about passing down of your wealth. Yeah. So there's a lot of difference in it. Wealth planning is about you during our younger days when our children were young. We actually try to pass down. We accumulate wealth. That's wealth accumulation principles. Yeah, there's so many principles about it. You don't put all your money in one basket, you know. I'm very sure you have bankers, relationship managers. You've got your financial planners who come and assist you on how to invest. As to whether this you know how to distribute wealth, that's a separate matter. In fact, it is also a separate skill set, if I may create this awareness to you. So for example, your bankers and financial planners, they help you grow your wealth. But there's another group of people or advisors who call themselves estate planners. These are advisors who actually advise clients on how to distribute the wealth, whether it's during your lifetime or after death. Yeah. So and it all depends on whether when you distribute your wealth, you would want to see your children grow them or spend them or preserve them for you. Or it could be you would want to have it distributed after death, whereby you are only concerned that your wealth or your assets just goes only one generation. It's a single generation or multi-generational. So it's all up to you. These are your choices, but you must know who you go to. I think in one of the events, there's this thing. There's a session called financial how to avoid financial scam. So this is one of the things that I would also like to impress upon our registrants, that getting the right advisors is very important. They must be qualified. In Malaysia now, we have financial planners who are properly trained. We have estate planners who are also properly trained, legally trained, and they know what they are talking about. So you have to know who you seek advice from. There's also in the industry, of course, there are lawyers. There are also trust companies. Trust companies are like Amanah Raya, CIMB Trustee, RHB Trustee. So these are trust companies who actually can deal with your assets after death. Yeah. So that's you need to understand the differences within the whole industry, within the landscape of wealth planning, so that you know the difference. And not all financial planners can advise you on the solutions for estate planning instruments. So you still need lawyers. You need probably trust service providers for you to understand to show the continuity. Yeah. So I hope I have given you a little bit of an idea of the differences between financial planners and estate planners. So can we move on to the next question? Yeah, and what life events does one need to be mindful of in wealth planning? It's well and easy when you have money, and you know how to spend your money. There are some clients of mine, because of they take risks, they take a lot of risks. So you must be mindful that when you have wealth, bankruptcy can actually affect you. Marriage changes a lot of things. Your commitment changes, the way inheritance is formulated changes. What happens during divorce? I just want to remind you that in law, marriage revokes a will, but a divorce doesn't. So you have to be, if you during your single days you were not married, you have a will. When you get married, please do amend it, revise it. When there is a divorce, if you don't amend it, then it will apply. It will continue to apply upon your death. So we've got clients who've got wills back in 1980s, and they have not updated it. So that can be quite of a problem, because 40 years later, you have children and grandchildren and all that. So please do update your will if you already have one. And there are new additions to the family, there's new generation, and different generation have different needs. They think differently, they view wealth differently as well. And what other life events are there when you are doing your wealth planning? You must think of unsoundness of mind. Statistics shows that we all live longer. So we've got quite a number of an aging population. So dementia sets in quite early nowadays, not just at 70. It could for some people it has been genetic. It can set in early in your life. So we need to plan ahead. You need to be aware of this, because the moment there is dementia, it's all too late to plan for your estate. Of course, death is also one of the events that you must be mindful of. So you have to chart your life, your stage of life, and see at which point of your life you need what instrument. Do you need a will? Do you need to update your will? If is a will sufficient? So these are the things that you need to be mindful of. If maybe you want to remove a beneficiary from your will, so update it. Those are the things that you have to be mindful of. Next question, perhaps we can. Question number 3, is a will the only solution? What other mode of wealth distribution other than inheritance? It all depends. It depends on it depends on you, whether you feel that your will can cover the multi-generational aspects of wealth distribution. So, of course, by default, for a non-Muslim, if you have a will by law, you can actually cover a lot of things. However, when you talk about assets that's worth, say, for example, 10 million ringgit, above 10 million ringgit, perhaps you are wondering whether it's wise to give it to your grandson or your granddaughter, who's or a delinquent child. Or is it how do you protect your autistic child, for example, right? So these are the things that you need to look beyond the will, because and who you appoint as your executor all matters. If you're appointing your brother, who's is your eldest brother, and you are already 50, your eldest brother is 70, so you have to think through, is that sufficient? Is that correct? Is that the correct way to go about with it, to take care of your probably autistic child? So is will sufficient the only solution? I would say no, but it all is dependent on your own circumstances. What other mode of wealth distribution other than inheritance? Have you thought about it? There's actually trust, there's gift intervivors, there's also, there are many other ways to go about with it. But again, it is dependent on your needs, your intention, and your objective. It is not the same for Muslims and non-Muslims, but actually there are many ways to go about with it. Yeah. So say, for example, your EPF. If you have an EPF um, nomination and you have not nominated anyone, then that spells trouble. That means you can't give your EPF proceeds to the people you actually wish to protect. For example, your parents, your spouse, or your children. Yeah. So when there is a nomination mechanism, please make full use of it. Now, as far as nomination is concerned, if you're a Malaysian, as far as EPF is concerned, if you're a Malaysian or if you're a foreigner, if you're a Muslim and a non-Muslim, it's all different. Yeah. So for a Malaysian, you should, if you're a contributor, then the nomination scheme is permitted. So if you can nominate and you have a name to appoint, please add that into your list. If you're a Muslim contributor to the EPF, then you actually can't, you can nominate, but the nominees are not your beneficiaries, they are actually your trustee. So they're supposed to hold it in trust for you for the rest of the Faraid S. If you're a foreigner in Malaysia, the EPF nomination is not valid. It is not permitted. So if you're an expat, for example, you're not a Malaysian, but you are contributing to EPF, so there are other mechanisms that we have to look at. So will alone is not sufficient. For example, a nomination scheme comes in the context of insurance proceeds. So if you've had your insurance nomination, please make your appointment of your nominees. If you have not, again, it will spell trouble, because that means you can't actually give it to it will go to the estate. So maybe these are undesirable people that you don't want them to receive. Joint accounts, for example. Joint accounts, depending on the intention. It's easy to say that in a joint account situation, the basic principle of survival takes all prevails. However, there are a lot of cases that, despite the fact that there is a joint account being set up between a father and a daughter, father and son, mother and father and mother, at the end of the day, sometimes the facts or evidence shows that it was not intended for the survivor to take it. It was intended to be held in trust for so and so, for example. So these are so why did I say that whether a will is not the only solution? Because a lot of times, despite the fact that you have the joint account, but you have other intentions. So you negated what the law is, and you complicate matters. So my advice is, if you have a joint account, if it's meant for the survivor, right? Make sure that the way you manage it and you operate it is meant for the survivor. It's not for convenience of the rest of the family. If it is meant for the convenience of the rest of the family, I advise that you actually make it very clear why that account was initially set up. Because there's a lot of disputes after death, because the bank will freeze the account upon death. And immediately after, that means the moment it's frozen, then there's a lot of other issues that comes about. So it all depends also on the operational matters, the administrative matters, on how it can really affect one's wealth distribution process. Yeah. So I would like to touch a little bit about medical directive. Medical directive is is in relation to, it's actually a letter that you write to your doctors or to your family members, informing them that you do not wish to be resuscitated, or, for example, you do not wish to take further treatments in the event of you going into comatose, or where you're not in the position to give your consent, right? do know that in Malaysia, we do not have the concept of living wills like in the UK or in the US. Yeah, likewise in Singapore, they have revised their law to provide for things like that, but we do not have that. So medical directive issued by a patient, it is not binding. It's just your intention. You is basically your instruction to your family members that if this happens to me, please do not resuscitate me. Please don't put me through all this harrowing experience of all this medication and all that. Just leave me alone, and let death be a natural thing. What that letter actually means, the medical directive letter means, is that the doctor take note of what your intentions are, but it does not stop the doctor from actually making sure that it's not a murder case, for example. Yeah, so basically they will still have to consult the family members. They will still seek the family the next of kin's consent on how to best treat the patient. So you have to understand, in Malaysia there are many types of instruments. However, they have very different applicability for different times, different stages in life, and also different phases, different trigger events. I see quite a number of questions coming in, but so perhaps I can probably go on to the next question so that we can move on to the questions, I hope. What actually happens? I think a lot of people will ask, actually, what happened after I die? What will my family do? So generally, it all depends on, as lawyers, I'm a lawyer. As lawyers, first thing first, we have to look at when the family come and see us. The first question we ask is it does the father or mother die testate or intestate? Testate means you die with a will. Intestate means you die without a will. Yeah. So if you die with a will, leaving a will behind, then we'll have to also identify who are your beneficiaries. Whether you have omitted a beneficiary in your will or not. Okay. Then if you die intestate, that means living without a will. Then what that also means is we still have to look at who are the legal heirs you leave behind. So these are the things that we have to find out. It helps if one of the practical things that I would like to share is that it helps if you can start compiling all your birth certs, IC, list of documents, your will, compile it nicely so that your family members can start preparing for our afterlife. Okay, so the other thing is we have to also identify whether the estate is solvent or insolvent. Solvency test is about whether you die a bankrupt. Yeah, so the test is whether your liability is higher than your asset. So your asset could be in the form of a real property, can be in the form of cash, unit trust, in many forms, your cars and all that. So usually what we do is we'll split the types of assets so that once we have classified them properly, then we will know whether you have a lot of credit card liabilities, income tax have been paid. So all that will have to be added, and then we will match it whether the estate is solvent or insolvent. Now, whether the solvency test is very, very important. Why? Because if your liabilities are more than your assets, then that means your estate is a bankrupt estate. If it is a bankrupt estate, basically your executors may have to pass it on to the Director General of Insolvency. So even if you have a will, that will cannot be fully executed. Yeah. So in terms of priority of distribution, what you have to know is that when we collect all the assets, then we'll have to actually pay first liabilities. What are the classification of liabilities? Number one, it will be your income tax. Of course, testamentary expenses is top priority. Yeah, as testamentary expenses would be funeral and things like that. I do know for not quite a number of non-Muslim clients are pretty much prepared, and they have booked and they have paid in advance their funeral rites, call their what do you call that, the burial space, you know, and things like that. So it's all taken care of. The second type of liability that you have to take care of will be definitely income tax. If the income tax have not been paid, these are statutory taxes, yeah, these are statutory liabilities. It has not been paid, we cannot use your money to actually distribute to your beneficiaries, whether in the will or to your legal heirs. And then there are other types of what you call this, liabilities. For example, your housing loans, car loans. So these are secured creditors. Probably they are secured creditors, yeah. But if you have taken up a credit card loan, for example, these are not secured creditors. What your bank can do is, on your death, knowing that, say for example, you have an outstanding credit card liability of even 20,000, yeah, which is, maybe it's not much to you, but to the bank it's a lot. So the bank can actually lodge a private caveat, a caveat against your estate. So unless your family pay for it upfront, then they will not release the estate from the liability. So these are the complication you have for estate matters. So when you look at estate wealth distribution, you need to also be mindful of what happens after death. Yeah. Then you have the issue of jurisdiction. If you have, if your estate is below 2 million, currently the law is that if the estate is below 2 million, then the jurisdiction of where you apply for your letters of administration is in the land office, provided there is a property involved, real property involved. Yeah. But if there's no real property involved, just cash below 2 million, then you can either go to Amanah Raya for a summary application, or you can go to land office. But if you die with a will, then you will have to, the jurisdiction is the jurisdiction of the civil court, which is the high courts. So if you know what happens, then when you plan or you want to give away your assets during your lifetime, you know for sure what your family goes through, what they will have to go through, and therefore you can plan ahead. So I'm going to go next onto how come why does it take so long, right, to settle? It's because we did not set it right for our children. Yeah, it's not just about the wealth distribution, it's the preparation for them to effectively manage our estate. So as a result, there could be family disputes, there could be the situation whereby there is an incomplete asset list, they don't know where your assets are. Yeah, so you've got digital assets, for example. You also have assets, suddenly you have an account in Singapore, you have an account in Australia, and nobody knows about it. Yeah, so what you have to understand is the process. The process of after our death, right, is when your family, just imagine your daughter having to rummage through your handbag, your cabinets, your office to actually compile assets, not taking into account the first stage of grieving. So after death, there's this grieving period, right? Some people take 1 month, some people take 2 years, some people take 3 months. It depends on how desperate the family is. Okay, so after the grieving period, say we give them 2 months, for example, yeah, then, and they don't know where you keep your will actually. So they call rock wills, they call trust companies, they call Amanah Raya to see whether there was a will placed or deposited with them, for example. So it helps that we prepare our children with compilation of documents, and just for your information, the compilation of asset can take as long as 6 months to begin. Yeah, because first it's trying to find where they are or what they are, and then trying to look at the documents, and then if there is a property, they should by right go and view the property. so that they have an idea of what it is, of the value and things like that. So it can take quite a while to compile the list of assets and liabilities for the purposes of filing in court. Okay, now then you have the filing period. Then you, if let's say you die with a will, then the process of going to the court is that you need the will, you need the list of assets. Even if you die without a will, you have to have the list of assets and also the list of liabilities. Even if you really don't know the total amount, we must have an idea. So the process is very different for someone who died leaving a will, which is a testate case, or someone who died without leaving a will. Is very different. If you die leaving a will, the best thing that you have done to for your family is that you have identified the beneficiaries. Well, whether they like it or not, that's a separate matter, but it's your intention, provided, of course, you have drafted a valid will, right? And then, and as far as process is concerned, they'll just have to go to court, get the grant of probate out. Once they get their grant of probate out, they will have to they go to the bank, take out the money and put it in one pool account before distribution is done. When it comes to property, they have to go to the land office, change name from the deceased to the executor, and then executor to transfer to the beneficiary. Trust me, that itself can be 8 months to 1 year. Yeah, so that process is the one that is long. It's not the going to court that is long. Okay, now if you die intestate without having a will, what does that mean? That means if you have immovable property, for example a house or a condo, number one, you did not give instructions as to who is going to be who should benefit which property, which means your legal heirs will the portion that your legal heirs were to receive will be as per the Distribution Act. Yeah, so the law takes into effect. The law is the default position. If the law is the default position, which means one house could be owned by 3 different people, which means if they agree to, say for example this claim, then there's also another cost involved, which is called the stamp duty. So stamp office, LHDN for that matter, will consider that as a double transfer. So these are all planning that you need to take into consideration. That maybe there's no real property gains tax, but there is stamp duty. Or there may not be stamp duty, depending on how we arrange it. There may be real property gains tax. The law is changing by the year, and we can't basically, as lawyers, we can't commit to what it is when the time comes. Yeah, so that's what the process is. It can take quite long. So if you can help your family by compiling your documents, for example, your death, marriage cert, your children's birth cert, your children's IC, list of assets and liabilities, and evidence, the documents, photocopy title, photocopy SPA, all that, if you can help them compile, put it in one cabinet, that will be the best gift you can give your executor or your administrators. So I think I have, I hope I have covered that. So I hope you can understand wealth planning is one part of it, the after death issues and the things that we leave behind, whether our children can actually pick it up and continue administering our estate. That's very, very important. Yeah, that determines how long the process can take. I would also like to share that we've got clients who are very organized. We could actually do that within 2 years. So yeah, it's very so it all depends on how organized we are. Okay, so wow, there's quite a lot of questions here. Raj, perhaps is there anyone here who can help me? Yeah.
Ms. Farah, thank you. Thank you so much for that insightful talk. And I know for one, I think I've learned so much more than from your talk this morning than I knew before that. So that's really appreciated. Thank you. Yes, we do have a bunch of questions. Let me just get that list of questions that have come in, and we'll get right into it if you're all right.
Sure, sure.
Okay, great. I'd like to highlight the first question is from Ong Kim. And they ask Miss Farah, if you are a single with older siblings and nieces and nephews by them, who should be the nominees in the will? Is it advisable to nominate your older siblings? And if they pass on before the will maker, the
Okay.
inheritance will automatically be passed on to their children according to the will that they have made.
Okay, so if you're single, it actually doesn't matter whether you're single or not, it really doesn't matter. The issue is when you talk about appointment of your representative, we call this personal representative. Personal representative there are two types. One is called an executor, the other one is called an administrator. The one who is appointed by the testator is the person who writes the will. The one who appoints, the executor appointed generally should be someone whom you trust. That's the first criteria. But trust alone doesn't help. It must be someone whom you trust. Number two, someone who's efficient. All right. Best practice is you must always have first line of original, we call it the original executor, whoever who you wish to name, having all those criteria, trust and efficient. So you must name them first, whoever that you want to name, but there must also be a substituted executor. You can have 3 levels depending on the type of estate you have. If your asset comprised of a lot of cash, no properties. I've got clients who's really, really cash rich. Okay. He only have 1 condo, and the rest of his assets are actually just easily can be liquidated. 1 condo, 1 car, and the rest are unit trust and cash in banks, FDs, and things like that. So if you are that kind of personality, having 2 level of executors probably is enough. But if you have probably you have 10 different properties, some outside Malaysia, some in Malaysia, some is Malay Reserve and all that, and you have 3 a big family, perhaps 3 level helps. Yeah, simply because you must also understand if your executor is an individual, a human being, as compared to a corporate trustee. They may also go through the same thing that you go through: death, incapacity, which is unsoundness of mind, or bankruptcy, or they even want to migrate, or they don't want to do they don't want to meddle with your estate. So they can also renounce. Yeah. So do also remember that they may say today, okay, I agree, Farah, to become the executor. And 10 years down my death, 10 years down the line on the date of my death, he decided like, oh my God, I'm not going to touch her assets. I would like to renounce. And every executor named under the will is given the right to renounce if they feel that they cannot cope. Yeah. So before grant of probate is being issued, they have a right to renounce. So therefore, and looking at circumstances, they might themselves be burdened by their own personal problems. So we must allow for substituted executors in the will. Yeah.
Great.
So what's
Thank you.
shall we move on
I
to
hope
the
that answers the question for you, On Kim. Now, another question that we have is from Zarifa Mustafa, who says that I have a disabled child who's 30 years old, married. I bought a house for him. Should I put his brother's name also, as my disabled child is unable to manage his finances? His wife is also not so capable.
Okay. Yes, you can. Whose question is that?
From Miss Zarifa Mustafa.
Zarifa. Okay.
Yes.
Yeah. When you say disabled, what do you mean by disabled? Is it well, he's married, so I assume he is I assume he's physically disabled, or it depends. Yeah. So if you're talking about disability, physical disability without affecting mental capacity, then perhaps the needs are different. You said that he is also married. I bought a house for him, should put his brother's name. You can, however, when you do that, you have to be mindful as to whether this property is actually could be deemed as a harta sepencarian or not. Naturally, because you bought it for him, it sounds like it's a gift to him. Then the issue of there being a wife, whether the wife have helped in the improvement of their property, that's another legal issue that we have to look at first. Yeah, putting the brother's name will help to then we have to identify what is the intention when you put the brother, your other son, to become the co-owner. Is he holding it in trust, or on death of your disabled child, does it go to your other son, or what is the intention? So these are things that makes things a bit more complicated. So we'll have to understand what is the real intention, and if it is not consistent with the law, because under National Land Code, yeah, property goes down. If you co-own a property, what it means is that 50% of yours actually goes down to your family. The other 50% goes down to the other family. Okay, there's a legal terminology for that, but I'm not going to go into that. So for your understanding, if your son is supposed to hold it for the disabled child, is it holding it in trust for your disabled child's children? Then the paperwork have to be prepared accordingly. Yeah. Well, I hope I have answered that question.
Yes, yes.
So it's not quite a straightforward answer.
Yeah, I'll quickly move on to the next question. We had the same question asked by two individuals here, by Mei-Ling Chua and Sharmila. Thank you so much for the question. A very short one. Is a self-written will valid or legal?
Yes, it is. You can write your own will. My answer is yes, you can write your own will, provided it complies with all the provisions of the Wills Act. For example, there are two witnesses. When you write it, you were in sound mind. And say, for example, I'll give you an example. If you were to write a will in the hospital, then you're going to have a problem whereby your family member, your family members who's not happy with that will may dispute it. So self-written will is valid provided you know what the legal issues are. Now, and the other thing is whether when you appoint a beneficiary, whether the beneficiary is a witness or not. So witnessing is important. How it's being drafted, your mental state is important. But do not oversimplify the fact that you don't want to spend money to get legal advice. So you just plug any will from the internet and draft something of your own, or you make a video, for example. You must remember under Malaysian law, only a written will is valid. Yeah, under Islamic law, oral and written will is valid. So it all depends on the facts. Then there are various laws applicable to it. Okay.
Great. Well, that's very, very insightful as well. Thanks. On to the next question, very quickly, from Alice Y. She asked if the executor and trustee is a Malaysian, but the beneficiary is a minor and a non-Malaysian living outside Malaysia, how can the executor and trustee execute the will?
No problem.
Not a problem, eh?
Not a problem, yeah. Because the executor is a Malaysian. You can even have a non-Malaysian executor, not a problem. Okay, the problem is whether it's wise to have a non-Malaysian as an executor, because there's a lot of things that an executor have to do. One is appoint lawyers, appoint real estate agent, go to the bank, sign documents in the land office. So there's so many things that's involved. You just imagine what an executor does. He steps into your shoes. On your death, he actually put on your shoes, walk to the bank, see a lawyer, and does all the things that you do. So you have to be practical about it. Have you provided enough cost for him to actually run the whole administration of your estate? Is there sufficient money? Is there cash available for him at the upfront? You know, what if your executor can't afford it? So these are the issues that you need to think of. So in relation to whether you can write a will, yes, you can write a will yourself, but have you thought of all this? So yes, you can have a Malaysian executor or a non-Malaysian executor. As far as a non-Malaysian beneficiary, you have to be mindful of the fact that whether there is income tax chargeable in the country of the beneficiary. Yeah, you have to be mindful of all the other legal and tax issues there. Whether if it's a foreigner, then maybe you need to get state consent. If it's a minor, maybe cannot. You have to you have to appoint the parents of the child and things like that. So I think getting proper and good legal advice would be good if it is not in the, if you know your wishes are not as simple as you think it is.
Great, great. Thank you once again, Ms. Farah.
Mm.
Ladies and gentlemen, I'm so sorry. That's all the questions we can take right now for today. But not to worry, for those questions that we didn't get Ms. Farah to reply, we've collected your questions. Rest assured that we'll, if that's okay with you, Ms. Farah, we'll forward them to you for you to help answer. And then we'll get back to the participants who've asked those questions that we were not able to ask during this Q&A session, okay?
Inshallah.
Great,
If
thank you.
whatever I can help, I'll do that.
Definitely. Thank you very much. Ladies and gentlemen, with that, I would love for you to join me to say a great big thank you to Ms. Farah Diba for her time today and for sharing such an interesting and useful insights with us. Now, very quickly as well,
Thank you,
the
Raj.
next person that we have, thank you, Ms. Farah.